Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in Kansas versus Garcia, certiorari to the Supreme Court of Kansas. Argued October 16th, 2019. Decided March 3rd, 2020. The Immigration Reform and Control Act of 1986, IRCA, makes it unlawful to hire an alien knowing that he or she is unauthorized to work in the United States. That's 8 U.S.C. sections 1324A, A1, and H3. IRCA requires employers to comply with Federal Employment Verification System, section 1324A-B, using a Federal Work Authorization Form, the I-9. They must attest that they have verified that any new employee, regardless of citizenship or nationality, is not an unauthorized alien by examining approved documents. Example, United States passport, alien registration card. Section 1324A, B1, big A, IRCA concomitantly requires all employees to complete an I-9 by their first day of employment and to attest that they are authorized to work. That's section 1324A-B2. Every employee must also provide certain personal information, including name, address, birth date, social security number, email address, and telephone number. It is a federal crime for an employee to provide false information on an I-9 or to use fraudulent documents to show work authorization. See 18 U.S.C. sections 1028 and 1546. But it is not a federal crime for an alien to work without authorization, and state laws criminalizing such conduct are preempted. That's Arizona versus United States. The I-9 forms and appended documentation, as well as the employment verification system, may only be used for enforcement of the Immigration and Nationality Act or other specified federal prohibitions. See sections 1324A, B5, and D2F. The IRCA does not directly address the use of an employee's federal and state tax withholding forms, the W-4 and K-4 respectively. Finally, IRCA expressly preempts any state or local law imposing civil or criminal sanctions upon those who employ or recruit or refer for a fee for employment unauthorized aliens. Section 1324A-H2. Kansas makes it a crime to commit identity theft or engage in fraud to obtain a benefit. Respondents, 3 unauthorized aliens, were tried for fraudulently using another person's social security number on the W-4s and K-4s that they submitted upon obtaining employment. They had used the same social security numbers on their I-9 forms. Respondents were convicted and the Kansas Court of Appeals affirmed. A divided Kansas Supreme Court reversed, concluding that Section 1324A-B5 expressly prohibits a state from using any information contained within an I-9 as the basis for a state law identity theft prosecution of an alien who uses another's social security information on an I-9. The court deemed irrelevant the fact that this information was also included in the W-4 and K-4. One justice concurred based on implied preemption. The Supreme Court held the decision was reversed and remanded, and Justice Alito delivered the opinion on the court. Kansas statutes under which respondents were convicted are not expressly preempted. IRCA's express preemption provision applies only to employers and those who recruit or refer prospective employees and is thus plainly inapplicable. The Kansas Supreme Court instead relied on Section 1324A-B5, which broadly restricts any use of I-9 information contained in an I-9 and any documents appended to an I-9, reasoning that respondents' W-4s and K-4s used the same false social security numbers contained in their I-9s. The theory that no information placed on an I-9 could ever be used by any entity or person for any reason other than the handful of federal statutes mentioned in Section 1324A(b)(5), is contrary to standard English usage. A tangible object can be contained in only one place at any point in time, but information may be contained in many different places. The mere fact that an I-9 contains an item of information, such as the name or address, does not mean that information contained in the I-9 is used whenever that name or address is used elsewhere. Nothing in Section 1324A(b)(5)'s text supports the Kansas Supreme Court's limiting interpretation to prosecuting aliens for using false identity to establish employment eligibility. And respondents' express preemption argument cannot be saved by Section 1324A(d)(2)(f), which prohibits use of the federal employment verification system for law enforcement purposes other than enforcement of IRCA, and the same handful of federal statutes mentioned in Section 1324A(b)(5). This argument fails because it rests on a misunderstanding of the meaning of the federal employment verification system. The sole function of that system is to establish that an employee is not barred from working in this country. The completion of tax withholding documents plays no part in the process of determining whether a person is authorized to work. Respondents' arguments that Kansas's laws are preempted by implication is also rejected. The laws do not fall into a field that is implicitly reserved exclusively for federal regulation, including respondents' claimed field of fraud on the federal verification system. The submission of tax withholding forms is neither part of nor related to the verification system. Employees may complete their W-4s, K-4s, and I-9s at roughly the same time, but IRCA plainly does not foreclose all state regulation of information required as a precondition of employment. In arguing that the state statutes require proof that the accused engaged in the prohibited conduct for the purpose of getting a benefit, respondents conflate the benefit that results from complying with the federal employment verification system with the benefit of actually getting a job. Submitting W-4s and K-4s helped respondents get jobs, but did not assist them in showing that they were authorized to work in this country. Federal law does not create a comprehensive and unified system regarding the information that a state may require employees to provide. There is likewise no ground for holding that the Kansas statutes at issue conflict with federal law. It is certainly possible to comply with both IRCA and the Kansas statutes, and respondents do not suggest otherwise. They instead maintain that the Kansas statutes, as applied in their prosecutions, stand as an obstacle to the accomplishment and execution of the full purposes of IRCA, one of which is purportedly that the initiation of any legal action against an unauthorized alien for using false identity in applying for employment should rest exclusively within the prosecutorial discretion of the federal authorities. Respondents analogize their case to Arizona versus United States, where the court concluded that a state law making it a crime for an unauthorized alien to obtain employment conflicted with IRCA, which does not criminalize that conduct. But here, Congress made no decision that an unauthorized alien who uses a false identity on tax withholding forms should not face criminal prosecution, and it has made using fraudulent information on a W-4 a federal crime. Moreover, in the present cases, there is certainly no suggestion that the Kansas prosecutions frustrated any federal interests. Federal authorities played a role in all three cases, and the federal government fully supports Kansas's position in this court. In the end, however, the possibility that federal enforcement priorities might be upset is not enough to provide a basis for preemption. The Supremacy Clause gives priority to the laws of the United States, not the criminal law enforcement priorities or preferences of federal officers. First judgment, second judgment, and third judgment, decision below is reversed and remanded. Justice Alito delivered the opinion of the court in which Chief Justice Roberts and Justices Thomas, Gorsuch, and Kavanaugh joined. Justice Thomas filed a concurring opinion in which Justice Gorsuch joined. Justice Breyer filed an opinion concurring in part and dissenting in part, in which Justices Ginsburg, Sotomayor, and Kagan joined. Thank you for listening. If you'd like to get a hold of us, we can be reached at rhodesscholar80@gmail.com. That's ROADS and 80, or on Twitter at Court Syllabus.